everyone. Very good evening. I believe not much participants have joined, but yes, motivating number. The intent of this quick kind of discussion is on adjudication order. As you all know that we have been sharing this adjudication compilation from last 1.5 years and more, right? But recently, I got one suggestion from one of the senior member at Abhinav. Why not make it as a monthly discussion or a weekly discussion where it can be done on a regular basis, right? And where we can discuss few important section and the adjudication orders which have been received in that section. So the intent is that only that will not take much time. We don't make it as a webinar mode. It will be moreover like when we are discussing any section, like I talk about section 12. So we'll just go through what section 12 is saying and whatever integrities are there in that section 12, right? And what are the orders which has been passed in under section 12 for the non-compliance of section 12, right? So that we can understand how and can have the you can say roadmap ahead to comply with section 12 for our companies or our client companies. Same way we'll be discussing for different section also, right? So the complete intent is that to make it a short one and make it a quick one, right? And this initiative I want can be taken from the participants end also. If anybody want to share any input, they can unmute themselves and share their input on the same. Simultaneously, if anybody want to take a lead, that no, I have one particular adjudication order which I want to discuss, right? We will give them a sharing right. They can share that order and they can discuss on it. So this trend we have started now. Today is the first day of this series, right? And it will try to keep conducting it on every Wednesday, right? So to start with, as we all know, Section 454, it's regarding the adjudication of the non-compliances under the Companies Act, right? And the very basic difference between adjudication and compounding is wherever in the Companies Act you are finding that fine is written, right? Then definitely we need to have to go for compounding. And wherever in the Companies Act penalty is written, definitely we need to go for adjudication. This is very clear-cut understanding for the same, right? So, with respect to Section 454, what is happening? Like, I will say, after 2019 onwards, right? A lot more sections had got decriminalized. The intent of this current government is to make this ease of doing business more accessible to all of us. So, in same parallels, and recently, I believe last year, there was a notification that now e-adjudication is happening. I believe it's happening on a 50-50 basis, right? Most of the time, like we are getting receiving the notices, we are replying on that particular portal which has been created for submitting our replies, and then this show cause hearing is still not happening completely on online mode. In some of the ROCs, it is happening on physical mode only, but sooner or later that will also be totally an online mode itself. So any company secretary who is sitting in two-tier cities or three-tier cities and saying that we are not blessed with a lot of opportunities due to this jurisdictional challenges. So I believe this is one of them. Like in 2017, trademark got there was a ease in trademark rules, but post COVID, this virtual hearing started. Right, the same way this adjudication orders and adjudication hearings will be the blessing for us. Right, so I believe it's right time that we should capture this trend. And as we all know that lot of new ROCs and RDs has been operational from last few of the months. So what is the intent? Like we have CPC for processing the forms. Pan India forms are getting processed at CPC. We have company CPAs for the closure of the companies. We have CRCs for the incorporation. Right? What is the intent? The intent is altogether very clear that these ROCs and RDs will be doing a wholesale, you can say, investigation, inspection, wherever it is required. So these are have been made operational to promote good corporate governance, I believe. Right? Same way, company settlement scheme came into the picture, which is effective from 15 April onwards. There, they have said that any non-compliance with respect to annual filing has been done in the past. Then, in after paying just 10% of the additional fees, you can do your filing. Same way, if you want to close any of the company, then just 25% of the closure fees, you can close your companies. So that window is open for 3 months only, right? So I believe it's good time that we should start introspecting, we should start discussing, and we should start evolving ourselves, right? So to start with, today's section is section 12. As you can see, I have created a small, in fact, team has created a small write-up on section 12. So let's go through that. If anybody has any input on it, then definitely it's most welcome, and we can take it forward. So Section 12 clearly says that any company within 30 days of the incorporation, right, and at all time thereafter have a registered office capable of receiving and acknowledging all communication and notice as may be addressed to it. So आपकी कोई भी कंपनी है उसका एड्रेस बहुत क्लियरली आपको इंटीमेट करना पड़ेगा, IC 22 फॉर्म के थ्रू आपको इंटीमेट करना पड़ेगा. बट एक नॉन कंप्लायंस जो रेगुलरली हो रही है दैट इज रिगार्डिंग दी nameplate. So under section 12, subsection 3, it is very clearly mentioned that every company shall paint or affix its name, number one, and the address of its registered office, number two, and keep the same painted or affixed on the outside of every office or place in which its business is carried on in a conspicuous position in a legible letter. And if the characters employed, therefore, are not those of the language or of one of the language in general use in that locality, तो जो आपका वर्नाकुलर लैंग्वेज है वो भी आपका पिक्चर में आता है. ऑल्सो इन द कैरेक्टर ऑफ द लैंग्वेज ऑन और ऑफ दोज लैंग्वेजेस हैविंग इट्स नेम engraved in legible letter character on its seal. और या फिर थर्ड है गेट इट्स नेम एड्रेस ऑफ ए रजिस्टर्ड ऑफिस और सिन नंबर विद टेलीफोन नंबर फैक्स इफ एनी email website address if any printed in all its business letter bill decks letter papers and in all its notices and other official publication. And D कहता है have its name printed on hundis, promissory notes, bill of exchange, and such other document as may prescribe, provided that where a company has changed its name or name during last 2 years, it shall paint or affix or print as the case may be along with its name the former name or names so changed during the last 2 years as required under clause A and C. Provide further that word OPC shall be mentioned in the bracket below the name of such companies where the name is printed, affixed or engraved. वाई आई एम रीडिंग इट बिकॉज एक बार ना सेक्शन को पढ़ना जरूरी है. सेक्शन को एक बार आप पढ़ेंगे देन ओनली जो हमारे आगे केस लॉज है राइट वी विल एबल टू रिलेट इट. तो क्रक्स इज दैट अगर आपकी कंपनी ओपीसी है राइट तो आपको ओपीसी मेंशन करना जरूरी है. अगर आपने कंपनी का नेम चेंज किया है तो लास्ट 2 इयर्स में अगर चेंज किया है तो आपको डेफिनेटली प्रीवियसली नोन एज एक्स वाई जेड प्राइवेट लिमिटेड वो आपको डालना जरूरी है, राइट. अगर आप का एड्रेस है तो वहां पे आपको प्रॉपर नेम प्लेट लगानी पड़ेगी जहाँ पे आपका कंपनी का नाम, आपका सिन नंबर, आपका रजिस्टर ऑफिस का एड्रेस, ठीक है, बहुत क्लियरली मेंशन होना चाहिए. सेम वे अगर आप अपना लेटर हेड यूज कर रहे हैं, वेबसाइट यूज कर रहे हैं, तो वो वहां पे भी एज पर सेक्शन 12 सब सेक्शन 3 क्लॉज सी के हिसाब से आपको सारी कंप्लायंस पूरी करनी पड़ेगी. अगर आप सेक्शन 12 की कंप्लायंस नहीं पूरी करते हैं देन डिफॉल्ट क्या है. Then it is very clear that if any default is made in complying with the requirement of this section, the company, पहली बात तो company and every officer who is in default shall be liable to a penalty of rupees 1,000 for every day during which the default continues but not exceeding 1 lakh rupees. तो मतलब मैक्सिमम डिफॉल्ट कंपनी पे 1 लाख होगा एंड एवरी ऑफिसर इन डिफॉल्ट पे 1 लाख रुपीज होगा एंड पर डे की पेनल्टी मैक्स 1,000 रुपीज रहेगी टिल डिफॉल्ट कंटिन्यूस. And further, if registrar has a reasonable cause to believe that company is not carrying on in business operation, he may cause a physical verification also of the registered office. That is very much possible, and I believe ये जो हम शेल कंपनीज का कॉन्सेप्ट पढ़ रहे थे पीछे 2016 में भी एक बार आया था शेल कंपनीज. तो द इंटेंट ऑफ द रेगुलेटर्स इज दिस ओनली कि अगर जो कंपनी काम नहीं कर रही है, ऑपरेशनल नहीं है, ठीक है, जिसमें कोई इन्वेस्टमेंट भी नहीं है, तो दोज कंपनी शुड आइदर बी क्लोज्ड और आरओसी शुड बी अवेयर ऑफ इट कि हाँ ये कंपनी है. और ऐसा नहीं होना चाहिए कि कई बार हम सुनते हैं कि एक वर्क प्लेस है वहां पे 200 कंपनीज रजिस्टर्ड है, ठीक है, एंड देन ट्रांजेक्शंस आर गोइंग ऑन. टू कार्व दैट थिंग दिस थिंग हैज बीन डन. अगर आप देखोगे अभी जो आप नया IC 22 फाइल करते हो उसमें लॉन्गिट्यूड लैटिट्यूड भी आप मांग रहे हैं फोटोज में, राइट. सो दीज आर दी स्टेप्स विच हैज बीन टेकन बाय दी रेगुलेटर्स. अब हम कुछ क्वेश्चंस पे आते हैं और उसके बेसिस पे जो ऑर्डर्स पास हुए हैं उस पे आएंगे. What happen if a communication is sent to register of the company is returned undelivered? कई बार ऐसा होता है. आज ही हमारे यहाँ का इंसिडेंट है. हमारे ऑफिस में कोई पोस्ट आना था बट दैट पोस्ट हैज बीन अनडिलीवर्ड एंड आई रिसीव्ड मैसेज फ्रॉम द पोस्ट ऑफिस डिपार्टमेंट that this has been undelivered because door was closed. So anyhow I was having the number, so I called him up. I said कि आपका मेरा डिलीवरी नहीं आया है. तो he said sir वो डोर पे nobody responded. Then I told him कि there was a proper letter box, you can drop it there. So he understood, but this is not the case everywhere. This was one of the case in the matter of Durance Healthcare Private Limited. अगर आप इसमें देखेंगे तो केस क्या था कि 25 अप्रैल 2025 को ऑनरेबल NCLT इंदौर ने जेविरन हेल्थ केयर प्राइवेट लिमिटेड को ROC ने एक लेटर इशू किया which was returned undelivered on 14/7/2025 with a remark left indicating non-maintenance of registered office. Accordingly, क्या हुआ, एक शो कॉज नोटिस इशू हुआ अंडर सेक्शन 454 रेड विद सेक्शन 12 सबसेक्शन 8। सेक्शन 12 सबसेक्शन 8 मैंने आपको ऑलरेडी बता दिया था। ठीक है। The company submitted its reply on 21/8/2025 and was granted an opportunity of hearing. Upon submission of documentary evidence, it was established that registered office was functional from 17/7/2025. Hence, the period of default was limited to 14 July 2025 to 16 July 2025. After giving an opportunity of being heard, ROC imposed penalty under Section 12, subsection 8, which is on company 3,000 and on every officer in default 6,000. Right? So, again, the key takeaway is very clear that the registered office is always functional. It should be always functional, and there should be a proper, you can say, board which should be displaying it, right? And we should have a proper proof that if sometime going forward, अगर आपका कोई भी letter undeliver हो जाता है, right? Then at least you can prove it कि नहीं आपने अपने registered office को functional कर रखा है। दूसरा एक और केस है, किसी को कोई व्यू पॉइंट है इस पे? Anyone who want to share any व्यू पॉइंट on this? Great. Move करते हैं next. Is it mandatory to mention sin on every official document of the company? अगेन हमने ऊपर पढ़ा था, बट एक और केस लॉ देख लेते हैं। ये है श्री रामकृष्ण मिल्स कंप्यूटर लिमिटेड का। इसमें क्या हुआ, कंपनी फेल टू प्रिंट एंड मेंशन इट्स सिन नंबर ऑन इट्स ऑफिशियल पब्लिकेशन, स्पेसिफिकली इन इट्स एनुअल रिपोर्ट फॉर द फाइनेंशियल ईयर 2013-14 to financial year 2022-23. Although such reports are circulated to shareholder and filed with agencies like stock exchange, the company contended that there was ambiguity regarding what constitute official publication and believed that annual reports will not fall under that category. But the adjudicating officer held that annual reports are authentic official publication and non-disclosure of sin therein constitute violation of section 12 subsection 3 clause C. अगर आप देखोगे तो we have discussed that section 12 subsection 3 clause 3 get its name, address of its registered office, and sin along with telephone number, fax if any, email, website address if any, printed in all its business letter, billheads, letter paper, in all its notice and other official publication. So ROC के हिसाब से annual report was a part of your official publication. Hence, आरुषि ने अपॉर्चुनिटी ऑफ हियरिंग दिया एंड देन दे इम्पोज द पेनल्टी एंड दिस वाज ए हार्ड पेनल्टी। नाउ कंपनी के ऊपर 1 लाख का पेनल्टी लगा एंड ऑफिसर इन डिफॉल्ट के ऊपर 5 लाख का पेनल्टी लगा। सो अगेन सम टाइम स्मॉल स्मॉल एरर राइट कैन क्रिएट अ ह्यूज लाइबिलिटी फॉर द कंपनी। सेम वे एक आपका एक और मैटर था इन द मैटर ऑफ ओम श्याम जी फूड्स प्राइवेट लिमिटेड। इसमें क्या हुआ, द लेटर हेड यूज्ड इन द बोर्ड रिपोर्ट ऑफ द फाइनेंशियल ईयर 2021 did not contain SIN number, contact number, and email address of the company, which is mandatory under the provision of Section 12, subsection 3, subsection 3 of the Companies Act 2013. The company acknowledged the omission and stated that it was unaware of the requirement, although the registered office address, contact number, and email ID remain unchanged since incorporation and were available in the ROC master data. Show-cause notice issue किया गया to its company and its officer in default under Section 450 of the Companies Act 2013, followed by an opportunity of hearing. And during the e-hearing, the authorized representative admitted the default and submitted that company qualified as a small company. Again, जब भी आप एडजुडिकेशन का सेक्शन पढ़ेंगे तो उसमें ना फिर आपका स्मॉल कंपनी को कुछ कुछ रियायतें दी गई हैं। ठीक है, तो हाउएवर अपॉन एग्जेम्पशन ऑफ फाइनेंशियल स्टेटमेंट फॉर फाइनेंशियल ईयर 1920 इट वाज डिटरमाइंड दैट कंपनी डिड नॉट फॉल विद इन द डेफिनेशन ऑफ, अगेन डिफॉल्ट पीरियड कब का था मेरा, 2021 फाइनेंशियल ईयर। ठीक है, तो यहाँ पे जो फाइनेंशियल स्टेटमेंट मेरा था 2019-20 का था। उस टाइम कंपनी डिड नॉट फॉल इन द डेफिनेशन ऑफ स्मॉल कंपनी अंडर सेक्शन 2 subsection 85 of the Companies Act 2013, and therefore the benefit of reduced penalty under section 446B of the Companies Act 2013 was not applicable. Again, जितने भी यहाँ पे जिन्होंने ज्वाइन कर रखा है उनके लिए एक होमवर्क है, सेक्शन 446B आपको जाके देखना पड़ेगा। अगेन कल को आपकी कंपनी के ऊपर कोई भी एडजुडिकेशन ऑर्डर आता है और अगर आपकी स्मॉल कंपनी है तो सेक्शन 446B में आपकी जो पेनल्टी है उसको रिड्यूस किया गया है। ठीक है, तो 446B को आप बिल्कुल ध्यान रखिएगा बिकॉज इट इज वेरी इंपॉर्टेंट सेक्शन एंड इवन स्टार्टअप पे भी एप्लीकेबल होता है ये। ठीक है, आफ्टर गिविंग एन अपॉर्चुनिटी ऑफ बीइंग हर्ड आरओसी इम्पोज द पेनल्टी अंडर सेक्शन 12 सबसेक्शन 8 एंड पेनल्टी देन अगेन वेरी वेरी मिनिमम पेनल्टी कंपनी के ऊपर 1,000 रुपए थी एंड ऑफिसर इन डिफॉल्ट के ऊपर 2,000 थी। Key takeaways is very clear that company and its director must ensure that all the official documents like board report, annual report display the SIN, contact number, email ID as required under section 12, subsection 3, clause C of the Companies Act. अब आता है मेरा तीसरा क्वेश्चन, दैट इज इट मैंडेटरी फॉर कंपनी टू डिस्प्ले और एफिक्स इट्स नेम बोर्ड आउटसाइड इट रजिस्टर्ड ऑफिस? ये भी हमने अभी पीछे सेक्शन 12 के डेफिनेशन में गो थ्रू किया है। ये मैटर है इन द मैटर ऑफ पनाशे फर्नीचर एंड इंटीरियर प्राइवेट लिमिटेड। हुआ क्या, पर्सन टू अ लेटर इशूड बाय एमसीए डायरेक्टिंग एन इंस्पेक्शन of the subject company. An inspection was conducted and inspection report was submitted thereafter. During the course of physical verification of the company, registered office by inspecting officer on 30th May 2019, it was observed that the premises were found closed and the name of the company was neither painted nor affixed at the registered office address. Subsequently, show cause notice was issued to the company, its directors under Section 454, read with Section 12A of the Act. However, no reply was submitted by the notice on the e-adjudication portal. An opportunity of being heard was provided through an e-hearing scheduled on 24 December 2025, but none of the notice appeared in that. Then अगर आपने शो कॉज हियरिंग पे भी वो अपेयर नहीं हुआ, उसके बाद द पेनल्टी आफ्टर गिविंग अपॉर्चुनिटी ऑफ बीइंग हर्ड, आरओसी imposed a penalty again company पे 1000 and every officer in default पे 2000. In my way, it was very lenient penalty which has been imposed, but it could be a higher side also, because as we have seen that under section 12 subsection 8, आपका 1 lakh rupees है maximum on the company and every officer in default. So we have to make sure that we are doing the compliance under section 12 subsection 3 clause A to avoid such defaults in future. एक और क्वेश्चन आता है, there's one more question, let me see. Yes, Hitesh, you are absolutely right. Under Section 446B of the Companies Act, half of the penalty will be imposed on the small company, startup company, and one-person company, with a maximum penalty of 2 lakh rupees for the company and 1 lakh for the directors. Basically, officer in default. अब एक और क्वेश्चन आता है, इज द कंपनी लाइबल इफ इट्स रजिस्टर्ड ऑफिस बोर्ड डिस्प्लेज नेम ओनली इन इंग्लिश नॉट लोकल लैंग्वेज? एनीवन हु वांट टू ट्राई दिस? अगर कंपनी का रजिस्टर्ड ऑफिस जो एड्रेस है, वहां पे जो बोर्ड है, उस पे सिर्फ और सिर्फ इंग्लिश में लिखा हुआ है, वहां की लोकल लैंग्वेज में नहीं लिखा हुआ है, तो क्या कंपनी हैज डन ए कंप्लायंस और नॉट, और देयर इज अ डिफॉल्ट? चलिए, the ministry directed an inquiry, again inquiry एक direction under section 2061 of the Companies Act. The inquiry officer submitted a report. It was observed that the company has not displayed its name board at the registered office in the local language as required under section 12 subsection 3 clause A of the act. चलते हैं जरा वापस section 12 पे, फिर से एक बार पढ़ देते हैं. Every company shall paint or affix its name and the address of its registered office, and keep the same painted or affixed on the outside of every office or place in which its business is carried on, in a conspicuous position, in legible letter, and if the character employed therefore are not those of the language or of one of the languages in general used in that locality, also in the character of that language or of one of those languages. So from there it is coming. Then a show cause notice was issued under section 454 and read with section 12, subsection 8 of the Companies Act. However, no reply or request for hearing was received. And then ROC imposed penalty on company rupees 1000 and on every officer in default 2000. So company must strictly comply with the requirement relating to the display of their name at the registered office, including displaying in its local language as mandated under section 12, subsection 3 of the Companies Act. सेक्शन 12 पे मेजरली हमें जितने भी ऑर्डर्स मिले, वो इन 3 या 4 क्वेश्चन के आसपास ही रिवॉल्व कर रहे थे. राइट, अगर किसी का इस पे कोई और व्यू पॉइंट या क्वेश्चन है, देन डेफिनेटली यू कैन शेयर योर व्यू पॉइंट हियर. देन उसके बाद हम नेक्स्ट सेक्शन जो आज का डिस्कस करेंगे वो सेक्शन 19 डिस्कस करेंगे. एनीवन? You have to make it a bit interactive. It's not one way, you can say, discussion which is happening. It's a two-way discussion. The intent is this only. I can see Dipanshu is there, Hitesh is there. Dipanshu, any inputs from your end?
जी सर, अभी तो आपके लेक्चर ही ले रहे हैं, ऐसे अभी तो इनपुट नहीं है।
Okay. Hitesh, any inputs from your end? चलो ग्रेट. नाउ सेक्शन 12 पे मुझे लगता है एक बेटर क्लैरिटी आज हुई होगी. स्टिल वी आर वर्किंग ऑन अदर आरओसी ऑर्डर्स विद रिस्पेक्ट टू सेक्शन 12. अगर कुछ न्यू इंसाइट इसमें आएगा डेफिनेटली विल शेयर. नाउ कमिंग टू सेक्शन 92. Section 92 subsection 4 says that every company shall file with a registrar a copy of annual return within 60 days from the date on which the annual general meeting is held, or where no annual general meeting is held in any year within 60 days from the date on which annual general meeting should have been held, together with the statement specifying the reason for not holding the annual general meeting, with such fees or additional fees as may be prescribed. अब Section 92, subsection 5 भी पढ़ लेते हैं. If a company fails to file its annual return under subsection 4 before the expiry of the period such therein, such company and its every officer in default shall be liable to a penalty of rupees 10,000, and in case of continuing failure, with a further penalty of rupees 100 for each day during which such failure continues, subject to a maximum of 2 lakh in case of a company and 50,000 in case of officer in default. ये हम सबको पता है बिकॉज टेक्निकली वी डू MGT7 फाइलिंग, राइट. अब इसमें आता है दैट व्हाट विल हैपन इफ कंपनी डज नॉट फाइल इट्स एनुअल रिटर्न टाइमली. हुआ क्या, एक कंपनी थी गैलेक्सिया टाउनशिप एंड हाउसिंग प्राइवेट लिमिटेड. इसमें कंपनी डिफॉल्टेड इन इट्स फाइलिंग इन एनुअल रिटर्न अंडर फाइनेंशियल ईयर 2021-22. A show cause notice was issued on 6/6/2025. No reply was received and no one attended the hearing schedule. And then the penalty ROC ने impose किया on company 56,500 and on every officer in default 25,000 on each officer in default. अब इसमें एक अंडरस्टैंडिंग है. जब 2019 में डिक्रिमिनलाइज हुए सेक्शन, उसमें क्लियरली इंटीमेट किया गया कि अगर आपने अपना सेक्शन 92 का नॉन कंप्लायंस किया है बिफोर यू आर रिसीविंग एनी शो कॉज नोटिस फ्रॉम द आरओसी, अगर आपने उसके रिसीव होने से पहले आपने नॉन कंप्लायंस को गुड कर दिया, मतलब आपने अपनी फाइलिंग्स कर ली, नंबर वन. या जब आपको रिसीव हुआ है उसके विद इन टाइमलाइन ऑफ 30 डेज अगर आपने अपनी नॉन कंप्लायंस को गुड कर लिया, मतलब आपने अपनी फाइलिंग कर ली, राइट, देन आप अंडर सेक्शन 92 आपको एडजुडिकेट नहीं किया जाएगा, राइट. सो सेम वे अगर कल को आपको कोई नोटिस आता है किसी भी आपके क्लाइंट के लिए कि उनकी एनुअल फाइलिंग नहीं हो रखी है, देन एडजुडिकेशन की प्रोसीडिंग्स आपके ऊपर तब चालू होंगी अगर आपने विद इन 30 डेज ऑफ दैट रिसीविंग दैट शो कॉज नोटिस आपने अपनी कंप्लायंस गुड नहीं की है. अगर आपने अपनी कंप्लायंस गुड कर ली है, डेफिनेटली यू वोंट बी, आपके ऊपर कोई भी एडजुडिकेशन की प्रोसीडिंग्स नहीं चलाई जाएंगी अंडर सेक्शन 90, राइट. So same with दूसरा question है that what will happen if company has failed to file annual return timely but filed with late fees before receiving the notice, as we discussed right now. In the matter of China Construction Samsung India Private Limited, company has failed to file its annual return for the financial year ended 31st March 2020. All the ROC has granted an extension of 3 months for holding AGM for financial year 1920 due to COVID-19 pandemic, making the due date for filing the annual return as 28 Feb 2021. The company filed the return only on 15 Feb 2023 with a delay of 717 days in contravention of Section 92 subsection 4 of the Act. A show cause notice was issued under Section 454, read with Section 92 subsection 5 of the Act, to which the companies replied on 18/8/2005, citing inadvertent delay caused by pandemic and requesting an e-hearing. During the e-hearing held on 13/9/2025, attended by the company's authorized representative, it was confirmed that annual return has been filed prior to the issuance of the notice. Then क्या हुआ, फिर under as per section 454 subsection 3, provided that in case the default relates to non-compliance of subsection 4 of section 92 or subsection 1 or subsection 2 of section 137, and such default has been rectified either to or within 30 days of the rise of the notice by the adjudicating officer, then no penalty shall be imposed in this regard, and all proceeding under this section in respect of such default shall be deemed to be concluded, as we discussed. तो अगर आपको कोई नोटिस आया है उससे पहले आपने अपनी फाइलिंग्स क्लोज कर ली है, या नोटिस रिसीव होने के 30 डेज के अंदर क्लोज कर लिया है, तो आपके ऊपर एडजुडिकेशन प्रोसीडिंग्स नहीं चलाई जाएंगी अगर आपने नॉन कंप्लायंस कर रखा है अंडर सेक्शन 92 सबसेक्शन 4 और सेक्शन 137 सबसेक्शन 1 एंड सबसेक्शन 2. Considering that default was rectified before the show cause notice date, in accordance with the provision of section 454 subsection 3, the adjudicating officer concluded that no penalty will be imposed and the proceeding is stood concluded. But इसमें भी there is a different understanding by a different you can say adjudicating officer. मैंने दो तीन केसेस देखे जो कि थे ऑफ दोज फाइनेंशियल ईयर विच वे बिफोर 2019, जैसे 2016 17, 2017 18, 2018 19 का। उसकी नॉन कंप्लायंसेस अगर हैं, उसकी अगर आपने फाइलिंग नहीं कर रखी है, आपने टाइमली फाइलिंग नहीं कर रखी है, then different ROC is taking different view. There have been an you can say a contradictory order which has been given by different adjudicating officer. In one of the case they have said कि आप उस अगर आपने नॉन कंप्लायंस कर रखा है अंडर सेक्शन 92 एंड अंडर सेक्शन 137, राइट, और ये नॉन कंप्लायंस आपके पुराने साल का है, लाइक 2016 17 17 18, देन आपको कंपाउंडिंग के लिए जाना। सो अगेन दिस इज वेरी सब्जेक्टिव, बट आई बिलीव अगर ये ईज आया है तो इट शुड बी एप्लीकेबल, एज पर माय इंटरप्रिटेशन इट शुड बी एप्लीकेबल फॉर ऑल दी यू कैन से नॉन compliances which has been done in past also. Otherwise there is no point bringing these amendments, or you can say ease of doing business will not prevail. Same way, we have raised this matter with various authorities also कि अगर कोई भी नॉन कंप्लायंस आपका है जो कि 2019 से 2018 से पहले का है, राइट, तो उस पे क्लैरिटी होना जरूरी है कि क्या उसमें अगर फाइन लिखा था पहले उस नॉन कंप्लायंस के लिए, वहां पे एक्ट में फाइन मेंशन था, बट जब आपका ये अमेंडमेंट आया उसके बाद वो फाइन पेनल्टी में कन्वर्ट हो गया। तो क्या आज के टाइम पे अगर हम उसका नॉन कंप्लायंस का गुड करने जाएंगे तो हमें क्या उसके लिए कंपाउंडिंग के लिए जाना पड़ेगा या एडजुडिकेशन के लिए जाना पड़ेगा? दिस एम्बिग्युइटी इज स्टिल क्रिएटेड, राइट, द रेगुलेटर नीड टू गिव क्लैरिटी ऑन द सेम। So different, again as I said, different ROCs having different opinions, but to some extent आई बिलीव अगर आज के टाइम पे आप कोई भी नॉन कंप्लायंस करते हैं, राइट, तो वो जो आज के टाइम पे अगर आपका पेनल्टी उसमें अगर मेंशन है उस पर्टिकुलर सेक्शन में, देन यू नीड टू गो फॉर एडजुडिकेशन इटसेल्फ. So these were the two short, I believe, sections which we have discussed today. So that why we have created these kind of concept. अभी तो आज first time था, तो we have created a quick gist. From next time we will create more detailed gist so that आपके लिए understand करना easy हो जाए. And this way we will be able to, right, you can say create that corpus of knowledge, right, and have more clarity on adjudication and those important sections जहाँ पे हमें regular adjudication के notices आ रहे हैं. एंड डेफिनेटली आई विल अप्रिशिएट अगर आप में से कोई इसको वॉलंटियर करे, आप में से कोई इसको टेकअप करे एंड अपने इनपुट्स भी लेके आए, राइट. I know time was short, but earlier from next time we'll mention those sections which we'll be discussing in our next of our virtual meet, so that we can make it more interactive. It should not be a one-way interaction. It should be always a two-way interaction, right? Any input from anyone? So I believe there is no input. So next time के लिए आप सबके लिए homework है. Whosoever have joined it, let's make it more interactive from next webinar. We'll be doing it on next Wednesday. We have freeze that date every week, and we'll be coming up with different section, right? अगर आपका कोई choice of section है, you can mention in the chat so that we can work on those section, right? अगर नहीं है तो definitely we'll be working on at least two sections, and we're coming up with that just on orders which we have received from various ROC with respect to those sections, and we'll be discussing in detail. I have received something. No. So thank you everyone. Thank you for joining. It was a short and crisp discussion on section 12 and section 92. So I believe एक brief understanding हम लेके जा रहे होंगे आज, right? And looking forward to have your participation and insight in future also. Thank you.